Marine insurance claims, fraud, non-disclosure and Uberrimae Fidei with Quadraant Legal. Introduction. Marine insurance is a specialized branch of insurance that protects ships, cargo, and related liabilities against risks at sea. For example, if a vessel carrying electronics from China to Europe suffers damage in a storm, marine insurance covers the financial loss. It plays a critical role in global trade, ensuring that businesses can manage risks and continue operations despite unpredictable maritime hazards. Rooted in centuries of maritime law, it remains a cornerstone of international commerce today. Principle of Uberrimae Fidei. Marine insurance is built on the principle of Uberrimae Fidei, or utmost good faith. This means both parties must act with complete honesty. The insured must disclose all material facts. For instance, if a ship has a history of mechanical failures, this must be revealed. The insurer, in turn, must provide clear terms and conditions. If either party breaches this principle, the contract can be voided. This foundation ensures fairness and transparency in high-risk maritime transactions. Fraud in marine insurance. Fraud is a major challenge in marine insurance. Some claimants may falsely report cargo as lost when it was delivered safely, or exaggerate damage to secure higher payouts. For example, a shipowner might present forged bills of lading to claim compensation for non-existent goods. In some cases, collusion occurs between shippers and insurers to exploit loopholes. Fraudulent claims not only undermine trust but also lead to legal consequences, including criminal prosecution and blacklisting in the industry. Non-disclosure issues. Non-disclosure occurs when the insured fails to reveal important information. For instance, if a shipowner hides the fact that the vessel has structural weaknesses, the insurer may deny claims after an accident. Similarly, concealing that cargo contains hazardous chemicals can invalidate coverage. Non-disclosure of prior losses also raises red flags. In such cases, insurers have the right to void the policy entirely, leaving the insured without protection. Transparency is therefore essential to maintain valid coverage. Case studies of fraud and non-disclosure. Several real-world cases highlight the dangers of fraud and non-disclosure. In one instance, cargo was misrepresented as harmless goods but turned out to be flammable chemicals, leading to a massive fire. Another case involved shipowners hiding defects in their vessels, which later sank, causing insurers huge losses. Fraudulent salvage claims, where parties exaggerate rescue costs, have also been reported. These cases damage insurers' reputations and emphasize the need for stricter checks and legal enforcement. Legal framework and enforcement. The legal framework for marine insurance is shaped by international conventions like the Marine Insurance Act of 1906, alongside national laws. Courts play a vital role in resolving disputes, often ruling against fraudulent or non-disclosing parties. Penalties can include fines, imprisonment, and cancellation of licenses. For example, in the UK, courts have consistently upheld insurers' rights to void contracts when material facts were concealed. Compliance with these laws ensures fairness and stability in maritime trade. Preventing fraud and non-disclosure. Preventing fraud and non-disclosure requires proactive measures. Insurers must conduct thorough due diligence, verifying cargo details and vessel conditions. Digital tracking systems, such as GPS and blockchain-based records, help ensure transparency. Independent inspections of ships before voyages can uncover hidden defects. Proper documentation practices, like verified bills of lading, reduce forgery risks. Finally, training shipping companies on compliance builds a culture of honesty and accountability, reducing fraudulent claims. Conclusion. In conclusion, marine insurance is vital for safeguarding global trade, but fraud and non-disclosure remain persistent threats. The principle of Uberrimae Fidei, utmost good faith, guides all contracts, ensuring honesty between insurers and insured. Legal frameworks provide enforcement, while transparency and technology offer modern solutions. For example, blockchain-based cargo tracking is already reducing fraud in shipping. Ultimately, maintaining trust and compliance is essential for the continued growth of international maritime commerce. The information provided here is for education purpose only and does not constitute as a legal advice or solicitation. Subscribe and join our community and stay informed. Welcome aboard. Like, share and subscribe.